All right, we're on the record.
Okay, good morning. It's February 3rd, 2025. This is Assessment Appeals Board number 2, and this meeting is hereby called to order. Brendan, could you do roll call, please?
Thank you. Board Member Cohen.
Present.
Board Member Wall.
Present.
Chair Lunetta.
Present.
Thank you.
Please stand for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, I see we're swearing in our newest member, Deborah Cohen.
Yes, thank you. Board Member Cohen, please stand. I'll now place Ms. Cohen under oath. Please raise your right arm and repeat after me. I state your name.
I, Deborah Cohen,
Do solemnly affirm that I will support and defend
do solemnly affirm that I will support and defend
the Constitution of the State of California
the Constitution of the State of California
against all enemies, foreign and domestic.
against all enemies, foreign and domestic,
That I will bear true faith and allegiance to the Constitution of the United States
that I will bear true faith and allegiance to the Constitution of the United States
and the Constitution of the State of California.
and the Constitution of the State of California,
That I take this obligation freely,
that I take this obligation freely
without any mental reservation or purpose of evasion.
without any mental reservation or purpose of evasion,
And that I will well and faithfully discharge the duties upon which I am about to enter.
and that I will well and faithfully discharge the duties upon which I'm about to enter.
Congratulations. Thank you.
All right, welcome.
Thank you.
Okay. Let's see. Brendan, to you, administration of oath.
I'll now place the members of the public present here today, as well as those of you on Zoom, under oath. Please stand. Please raise your right arm. When I complete reading your oath, please state I do. You and each of you do solemnly affirm that the testimony you're about to give and the matters now pending before this board will be the truth, the whole truth, and nothing but the truth. Thank you. You may now be seated.
Okay, thank you. Looks like we have an agenda review.
Yes, thank you. Item 6, agenda review for February 3rd, 2025. The clerk of the board recommends approval of the agenda review by the Assessment Appeals Board. The agenda review consists of the following agenda items. Item 14, application 22-10894, applicant Wiegand Farms, deny due to lack of appearance. Item 31, application 23-10450, applicant Jeffrey Malachar, removed from the agenda due to submission of a withdrawal. Item 35, application 23-10945, applicant SWVP Westlake LLC, continued to March 17th, 2025, pending receipt of the original stipulation. And item 42, application number 23-11142, applicant Mark Schlossenberg, denied due to lack of appearance. That completes the agenda review. Recommended action is to approve as read.
Okay, do I have a motion to approve the agenda review?
I make a motion that we approve the agenda review as read.
I concur.
All right, we have a motion by Board Member Wall, second by Board Member Cohen. Any objections to that motion? Hearing none, that passes unanimously. Thank you.
Okay. Do we have any public comments, Brendan?
We believe everyone present this morning is for an item on today's agenda, so there are no general public comments at this time.
Okay. And do we have any board comments?
I have none.
And none here.
Okay. I just want to say again, welcome, Deborah, to Assessment Appeals Board number 2. Okay. We can get into the regular agenda. Okay, application number 21-10601, Jose G. Reveles.
morning,
Good morning, sir.
Chairman Lanetta and the honorable board members. I have,
Not yet. Not yet. Not yet.
sorry, I'm very sorry.
So are we moving forward with your case today?
Yes, I am expecting the applicant, the appellant, I am his attorney, and I can proceed on his behalf.
Okay. And your name, sir?
Dionisio Costales.
Dionisio Costales, okay. Excellent. And do you have an idea about how long you think your presentation will last?
It won't be long, Chairman, 10 minutes.
Okay. Okay. Excellent, thank you. We will come back to you.
And real quick, do we want to check in and see if the assessor's prepared to present this morning?
That's a good idea. To the assessor, good morning.
Good morning. Joe Phillips with the assessor. The assessor is also ready to move forward. We anticipate about 20 to 30 minutes for our presentation.
Okay, thank you.
And Mr. Costales, are you still requesting written findings of fact?
Yes.
Okay, and you
Yes,
have
Mr.
payment of $150 with you this morning?
I can make out the check,
Okay,
yes,
we'll
Mr. Clerk.
sort that out before the actual hearing begins. Thank you for
Thank
confirming.
you.
Okay. Moving on to item number 10, application number 22-10711, Albany Apartments of Oxnard LLC.
Chair Lunetta, we have James Allen.
Good morning, James Allen for the applicant.
Good morning, sir. Are we moving forward with this case today?
We are, if the assessor's prepared.
Okay. And approximately how long do you expect your presentation to last?
15 minutes, but I may have additional time for rebuttal.
Okay. And to the assessor, are you prepared to move forward with this case today?
Zachary Clifford with the assessor's office. We are not. It is the opinion of the assessor that the applicant has not fully complied with our 441D requests.
Okay. Mr. Clifford, could you give me a quick recap on this case?
Sure. Well, I'll sort of sum it up in the information that we believe is still outstanding. The applicant is asking us to consider a significant amount of goodwill that was purchased when he purchased the property, along with inventory of the business. He has not shown evidence that the business actually closed escrow or that he purchased any business at all. And we're requesting for those documents, whether it's a closing statement. He's provided us an inventory list of the personal property purchased, and we're thankful for that. But according to the purchase and sale agreement that he did provide, the business was under escrow, but there was never a closing statement provided letting us know what the final sale price of the business was.
Right.
We've continued to request that with no avail, as well as market and cost evidence that he himself has derived to support the allocations he's requesting to the land and to the improvements and to the goodwill or the business enterprise value. And I'll let the applicant speak for himself on those issues.
Thank you. Mr. Allen, let's go hear your input.
Thank you. There's actually two issues that I bring before this body today. One is the allocation of the value of the structures to the land. That was changed in the 2024 assessment from approximately almost 70% to structures down to less than 5% for structures, without any explanation and without any reason for doing so. I also I provided the closing statement for the transaction and the reason why it closed that way. The transaction closed for $2 million. When we acquired this asset, we were acquiring the business and the land and with the structures for future development and operation in the meantime. Following our acceptance of our offer to acquire all of those things. There was a litigation instituted by the prior buyer who was in escrow to buy the business. And that litigation ended with or caused a lis pendens to be recorded against this property. I provided all that documentation to the assessor's office. I also provided a rather extensive list of the income from the business that was provided to us in escrow. But what happened during the course of the escrow was we were forced to close as one transaction. So the transaction closed as a $2 million transaction, and the allocation between the business and the property, including land and structures, was set forth in the preliminary change of ownership report, which indicated that we were paying $500,000 for the business, which included the inventory, which was extensive, and we have provided pictures of all that in our presentation to the assessor, and the income from the business, which was significant, and we provided proof of that to the assessor. So on January 14th this year, we were formally asked to provide the same information to the assessor again, which we had already provided, but we again provided further information. So I don't believe a lack of compliance on our part is the reason why this has not been looked at again and more closely by the assessor's office. We're prepared to go forward. There's nothing further I can provide to the assessor's office. We've provided them extensive documentation, hundreds of pages of documentation relative to the way we value the property, the allocation between the structures and the land, which we've asked for the same allocation for the two contiguous properties. This property is 70% for structures, and $70 a square foot for structures, which is consistent with what was 70% for structures, I'm sorry, which is also comes to about $70 a square foot,
Okay.
but that's consistent with the two contiguous properties that are for the same purpose. What we'll get back is a belief from the assessor that we acquired land value only, which was not the case, and which we've tried to demonstrate to the assessor. But it feels as if we're not being, our evidence is not being either looked at or heeded.
Okay. Well, oh,
Sorry,
Go
if
ahead,
I may add,
Mr. Clifford.
it is the opinion of the assessor that the business ceased to exist at the time of close of escrow. So it is our opinion that there was no business transferred, and the applicant has yet to provide evidence of that. We're certainly willing to consider that if that actually occurred. But as of the close of escrow, it is the opinion of the assessor that the business, the applicant bought a building and land and some personal property, and the business was not functioning at the time of close of escrow. So that is where and we have not been proven otherwise. That was how the original assessment was made, and we still believe that, and we're waiting for the applicant to provide evidence that the business was actually operational as of the close of escrow, which may change our assessment if he's able to provide that information.
okay.
And in response to that, the business, I indicated that there was litigation that ensued. The litigation was the other party who was interested in acquiring this asset was attempting to acquire an ongoing school. It was a nursery school and elementary school up to grade 8. It was a Mary Law school. And that litigation and the lis pendens put on it forced us to, in order to resolve this case, to close without receiving the benefit of the business, because in order to close it, that litigation forced us to basically acquire the asset and then attempt to continue the business. Well, the business was licensed to the seller, and the seller, as of close of escrow, well, they indicated they were willing to go forward in their purchase documents, or their sale documents, I should say, Well, they indicated they were willing to go forward, lease the property back, which was what we had intended, acquire the asset, acquire the business with them operating as licensees and paying rent and having this a profitable transaction. That litigation forced us to change in the last month of the transaction in order to get the transaction done. So it was litigation filed here in Ventura Court, which I've provided copies of. I have copies of here, went on from basically June of 2020 till December of June of 2021 till December of 2021, when we closed, that forced us to acquire this asset and end up with a business that we could not operate.
Okay. Well, the assessors indicated that they're not prepared to go forward today. Is that correct?
That's correct.
Okay.
We would also need time to perform a site check at the property as well.
Yeah.
And so,
Well, it seems to me that, Mr. Allen, the information that the assessor's requesting would only benefit you. So if you can't give them anything more, then I would assume that the assessor can go forward without that information to
yes,
present their case.
we can present, we're attempting to give the most benefit of the doubt to the applicant in providing us the information for the business.
Right.
And if that's the case, we'll continue with our case. If those documents don't exist or he has nothing else to provide.
Okay, and so I assume, though, the assessor will still need a continuation in order to prepare.
That's correct.
Okay. Mr. Allen, does that make sense? What I'm
I'm
suggesting then
fully-
is that we go ahead and continue.
I think the best thing for the assessors is to meet in person, because basically things get continued and shoved to the back shelf, because there's other things coming up. So I don't mind meeting with Mr. Zachary at his next opportunity and walking him through it, because I think it's kind of, the two issues are both fairly straightforward,
Right.
Yeah, yes, I understand that we paid $2 million and anticipated receiving a business, and the litigation stopped it, and all that documentation is here in the court right across the next building over.
Right.
So that's pretty straightforward. And our argument with the assessment is we were assessed as raw land only, and there's buildings on there that we intend to utilize in our long-term goal, which is to convert existing buildings to the extent we can to an apartment complex, which it appears was the original design for these particular buildings. And we're pursuing those plans and are hopefully the last portion of our application to the city of Oxnard to get that done. Now, I've got all that documentation. I'd be pleased to sit down with Mr. Zachary, but I think we need to take some time and maybe spend an hour and go through it and see if we can't hammer it out.
Okay. So what I'm suggesting then is that we pick a date for continuation. In the meantime, obviously, Mr. Allen and the assessor's office will be in communication.
Yes, so just to quickly sum up, basically the applicant is indicating there's a certain amount of business value with the property. We're just seeking documentation to somewhat prove that so that we can incorporate that into our appraisal. It sounds like sitting down and both parties meeting and discussing all the details is going to be highly productive. With that in mind, it's likely that the next hearing, if we are unable to come to an agreement, would be hearing the case fully. This is a bit of a complicated issue, so we do want to request if we can push it out possibly a little bit further than April, just to give both parties plenty of time to prep for the next hearing.
Yeah, that's understandable. Brendan, what else do we have? What's our next?
Yeah, let me see another date. And Mr. Allen, are you agreeable to going out beyond April with the hearing?
Yes.
Okay.
Whatever, I want to just get it resolved.
Okay, I mean, we need to set a date, a realistic date, but best case scenario, you and the assessor work it out before that date, and you don't have to come back.
So beyond April, we could do May 19th or June 2nd. Does either of those dates sound agreeable to you, Mr. Allen?
I prefer May 19th, if that's acceptable to the assessor.
Yes, that works for the assessor.
Okay. All right.
And the assessor is requesting, if possible, the data within the next 30 days and a site inspection. Is that correct?
Yes, next 30 days from today would be best.
Okay.
Mr. Allen, is that acceptable to you, to provide any additional information as well as provide a site inspection within the next 30 days to the assessor?
We'll provide a site inspection for sure. I'd like to meet with the assessor while he's doing the inspection. We've already sold off the personal inventory, but we have photos of it in place
Okay.
when it was operated as the Mary Law School. So
And is 30 days enough time to provide any additional information that the assessor may need?
yeah, particularly if we could meet within the next week or so, if that works for Mr. Zachary.
To the assessor?
We could meet after their agenda review if you're willing to hang around here for another half an hour or so.
Certainly. I think I've got stacks of documents
Okay.
right here with me, or everything I have I brought, so.
Okay, after the agenda review, when we conclude, I'll have some time and I can meet with you.
All right, thank you.
Okay. Looks like we have,
19th, 9:30?
yeah, we're going to, I'm looking for a motion to continue to May 19th, 2025, with a data proviso that any additional information be provided to the assessor within 30 days.
I move that we continue to that date with the data proviso 30 days from today.
And I second.
Hearing no objections, the motion carries. Thank you, sir.
Thank you.
Okay. Item 10, or I'm sorry, item 11 through 13. Application numbers 22-10829 through 22-10831, Westlake Portfolio LLC.
Chair Lunetta, we have Dylan Hoyes with Paradigm Tax Group in person.
Okay.
Good morning, everyone.
Good morning, Mr. Hoyes. Are we moving forward with this case today?
We're going to need some more time on this one. We would like to request April 4th, and we'll gather the documents that we have, and in the meantime, so I think April 4th would probably be best for that.
We have March 17th and April 28th are our dates.
Oh, April 28th, that'll work.
And to the assessor?
The assessor agrees with the continuance request. We haven't received any information for this one yet, so if we could have a 30-day proviso, 30 days from today would probably be best.
And to the applicant, is that acceptable?
We're agreeable with that.
Okay.
Thank you.
Then I'm looking for a motion to continue to April 28th, 2025, with data due to the assessor within 30 days.
I move that we continue this to the April 28th date with the data proviso 30 days from today, provided to the assessor.
Second, I second that motion.
And hearing no objections, the motion carries. Thank you, Mr. Hoyes.
Thank you.
Okay, item 15, application number 22-10915, Movico Entertainment Lessee American Multi-Cinema, Inc.
Chair Lunetta, we have Michael LeBeau with Bewley, Lastman and Miller LLP in person.
And I just add before we hear from Mr. LeBeau, item 16 is for the same property for the subsequent year, so we can
Okay.
discuss item 15 and 16 simultaneously. Thank you.
Excellent.
Good
morning.
morning, Mr. Chairman. Good morning, members of the board. Michael LeBeau of the law firm Bewley, Lastman and Miller for the applicant AMC. It is good to see Board Member Cohen again. There has been issues, the 2022 and 2023 decline in value assessments of the theater at the mall in Thousand Oaks is the subject here. The assessor's office had the all of our package for the 2023 lien date. Come to find out today that there's still more data needed for 22. I have given the assessor's office my entire intended presentation. And if we go to a hearing, I think that everything has been provided now. And I'm going to request a continuance to the March 17 date so that the assessor's office has an adequate amount of time to review the 22 materials. And hopefully we can resolve this. The movie theater industry has been under incredible pressure since COVID. And they've been trying to sell this theater for quite some time with no bites. And we believe that there's a significant decline in value for this location.
Okay. All right, thank you. And to the assessor?
Yes, we agree with everything stated by Mr. LeBeau. He provided some information this morning that we will be reviewing. We agree with March 17th, and if we could just add a 30-day proviso in the event more info is needed, we have to review it to see if anything is needed from
Got
there.
it. Okay, Mr. LeBeau, is that acceptable?
It's acceptable, but like I said, I've given them my entire expected presentation.
Okay.
So, and I would ask that that we move forward that day if we can't reach a resolution.
Okay. Okay, looking for a motion to continue to March 17th, 2025 with any additional data due to the assessor within 30 days.
I have a question for either the assessor or Mr. LeBeau. Has the 22 data been provided before today? It's the 23 data that just came in today, correct?
Flipped. So
Oh, just the other way around.
we got all of 23. We were waiting on 22. So we think we got all of 22 this morning. We just have to comb through it.
It was an oversight. It was flipped, as the assessor's office said. They received, the last time the board met in person that I was here, they received their entire 23 presentation, and there was missing data elements for the 22 presentation, which were provided to them today in the binder.
Based on what I'm understanding today, I'd like to move that we continue both of these cases to the March date
Yes, please.
and with a 30-day data proviso to the assessor.
I second that motion.
Okay, and with no objections, the motion carries. Thank you, Mr. LeBeau.
Thank you, Mr. Chairman. Thank you, members of the board. Thank you to the assessor's office and to the board clerk's office. Thank you.
Okay. Let's see. It looks like items 17, 18, and 19
That's correct.
will probably be combined. Applications number it's 22-11329, 22-11420, and 23-11418, North Shore Healthcare Holdings LLC.
Chair Linetto, we have Christian Tucker with Altus Group in person.
Morning, Board.
Good morning.
We'll need more time on this. We need to gather some information from the tenant. We don't really have a relation with the tenants. We need time to establish that and try to get that information to the assessor.
Okay, and do you have a preferred date for a continuation?
I would say April would be better for us.
Okay. And to the assessor?
Yes, that works for the assessor, as well as if we could add a 30-day proviso from today.
And to the applicant, is that acceptable, the data proviso?
It is.
Okay. Looking for a motion to continue to April 28, 2025 with a proviso that data be provided to the appraiser within 30 days.
I'd like to make that motion that we continue to April 28th and with the data proviso that the data gets to the assessor within 30 days from today.
I second that motion.
And with no objections, the motion carries.
Thank you,
Thank
Board.
you, sir. Okay, and looks like we have items 20 and 21. Application numbers 22-11336 and 22-11337, Bright Peninsula Road LLC.
We have Dylan Hoyes with Paradigm Tax Group in person.
Good morning again.
Good morning again, Mr. Hoyes.
We would like a little bit more time on this one. We've had some back and forth with the client. I think we'll be able to probably resolve this in the near term. However, probably need to pick that April 28th date for a continuance here.
Okay.
Squared away.
To the assessor?
Yes, the assessor's okay with the continuance. This one, we need a 30-day data proviso since we haven't received information yet on this one.
Okay. And Mr. Hoyes, is that acceptable?
Yes,
to
sir,
you?
it is.
Okay. Okay, we're looking for a motion to continue to April 28th, 2025, with the data proviso. Any additional information be provided within 30 days.
I'd like to make the motion, continue to April 28th with the data proviso from 30 days from today, be provided to the assessor.
I second that motion.
No objections, the motion carries. Thank you, Mr. Hoyes.
Thank you.
Mr. Chairman, while we have Mr. Hoyes up here, it may be more efficient if we jump to items 24 through 26 and 27 through 29, which are also for Mr. Hoyes.
Okay. And those two are, or those are all one,
Yeah, they're
one owner or one property?
semi-related. HM Anacapa IL LLC and SMH Ventura IL LLC. They're marinas at the respective harbors, but I think we can hear
Okay.
them simultaneously.
Okay, well, we'll hear from Mr. Hoyes again.
Yes, my understanding is we're going to need some time. I believe I provided everything that's been asked for, but some of that remaining information was just provided last week. So, we're agreeable to April 28th while we, continue to work to potentially come to an agreement beforehand.
And does that apply to all of these applications?
Yes, sir, it does.
Okay.
Yep.
And to the assessor?
Yes, the assessor's in agreement. So if we could continue and also add a proviso, we do need some time to go over the information we just received. And if we may need more information, we may not. I'm not sure at this point.
Okay, and 30 days from today?
Yes.
Okay. Mr. Hoyes, is that acceptable to you?
Yes,
Okay.
we're good with that.
Okay.
I'd like to make a motion that we continue to April 28th with the data proviso that the assessor receive information 30 days from today's date.
I second that motion.
And to clarify, this is for items 24 through 29. Hearing no objections, the motion carries. Thank you, Mr. Hoyes.
Mr. Hoyes has one more item on the
Oh,
agenda. If
okay.
we 44 through 45 on page 6 of your agenda. We just want to address that real quickly.
Yep. Okay. Items 44 through 45, application numbers 23-11533 and 23-11534, Vaughn's Companies, Inc.
Yes, sir. I believe we provided everything we have, including 2 appraisals, which were provided last week or 2 weeks ago. So I think in the meantime, we're trying to come to a resolution, I believe, and I expect we will, but we'll probably need the 28th, April 28th request.
Okay. And to the assessor?
Yes, that's correct. We agree with the continuance. This one, we don't need a data proviso, so we'll either come to a resolution or hear the case at the next hearing.
Okay. Looking for a motion to continue to April 28th, 2025.
I make the motion that we continue to April 28th, 2025.
I second that motion.
And with no objections, motion carries. Okay.
Thank you, board members.
Thank you, Mr.
Appreciate it. Thank you,
Mr.
guys.
Hoyes. All right. Back to. Okay. Okay. I think items 22 and 23, applications number 22-11417 and 23-10313, TO Lakes LLC.
Chair Lunetto, we have Michael P. Kelly on Zoom for these items.
Okay. Good morning.
Michael Kelly with Agilot Poly AU Matarisi and Groge on behalf of the applicant.
Good morning. Are we moving forward with this case? I'm assuming not.
That's correct. We are not. We have, this involves the Lakes of Thousand Oaks Retail Center.
Yeah.
We've been working cooperatively with the assessor's office. before the board, there was some outstanding information. We've since exchanged that information. We understand the assessor is working up their valuation and working through management, and we are hopeful that we could come to a resolution. I think we just need a little more time to fully explore that.
Okay. And the dates we have for continuation are March 17th and April 28th.
So if I may defer to the assessor's office, I'm not sure where they are in the review process, or how quickly they might have a response on
Right.
their valuation.
Okay.
We could do that first.
To the assessor's office?
Yes, so we would request the April 28th date. As the applicant mentioned, these cases will likely need management review in our office, which does take a little bit more time, so.
Okay. And is there any data proviso needed?
Yeah, so no data proviso for these ones.
Okay. Then I'm looking for a motion to continue to April 28th, 2025.
I move that we continue to April 28th, 2025, no data proviso.
I second the motion.
No objections, the motion carries. Thank you, Mr. Kelly.
Great, thank you all. Have a great day.
Thank you. Okay. Item 30, application number 2310273, Palmer Ventura Properties, LP.
Mr. Chair, this is a request to vacate a stipulation approved on April 8th, 2024 due to a ministerial error and a request to approve a corrected stipulation agreement. This was emailed to your board on Friday. It was a small issue with the incorrect starting value listed, which prevented the county's auditor controller from processing the reduction. So the requested motion from your board today is to vacate the stipulation approved on April 8th, 2024 and approve a corrected stipulation agreement. We're available for questions if you have any.
Okay. I received that information last week. Did my fellow board members also receive that?
I did.
Yes, I did.
Okay. Then I am looking for a motion to vacate stipulation that was previously approved on April 8th, 2024, and approve the corrected stipulation agreement.
I move that we vacate the original stipulation and are we approving a new stipulation?
Yes, that was part of your packet
Yes.
as well.
Okay, yes. I make that motion.
I second the motion.
There are no objections, the motion carries. Okay, items 32 and 33, application numbers 2310816 and 2310817, TV Oxnard Bliss LLC.
Chair Lunetta, we have Richard Dennis on Zoom for these items.
Okay. Good morning.
Good morning. My name's Ricky Dennis. I'm the agent for the applicant.
And what would you like to do today, Mr. Dennis?
The assessors requested some additional information about a week ago. We provided it for them, and they've asked us to give them some additional time to review that information. So we'd like to reschedule the hearing to March 17th.
And to the assessor?
Yes, March 17th works for the assessor. As the agent mentioned, the information was received last week, so we do need some time to review that and see if any additional information is needed. So if we can get a 30-day proviso just in case.
30 days from today's date.
Yes.
And Mr. Dennis, is that acceptable to provide any additional information within 30 days?
Absolutely.
Okay. Go ahead.
I'd like to make a motion that we continue to March 17th with the data proviso that the applicant gives the assessor any requested data within 30 days from today.
I second the motion.
There are no objections, the motion carries. Okay. And, okay, item 34, application number 23-10819, Townsgate Property LLC.
This is a similar situation. We provided the data on September 16th last year, and the assessor requested some additional data on January 7th, January 15th, and we provided additional data those 2 dates. And I think they just need more time to review it. And we would also request that that hearing be scheduled on March 17th.
Okay. To the assessor?
Yes, we agree it's the same situation as the previous one. So if we could get a 30-day proviso, just in case.
Okay.
I move that we continue this case to March 17th with a data proviso 30 days from today to provide information to the assessor.
I second that motion.
And there are no objections. The motion carries. Thank you, Mr. Dennis. Okay. Okay. Let's see. Application, or items 36 through 39, application numbers 23-10951 through 23-10954, Ventura Riviera Resch et al.
Chair Lunetta, we have Tanner Brawl here in person.
Good morning, everyone.
Good morning, Mr. Brawl. What would you like to do today?
We've provided all the information to the assessor's office. They were waiting on our evaluation, and we've sent that over to them. We've agreed. We just need more time to see if we can come to a resolution. I think 428 would work best for us. We won't be available on the 17th. So if that's okay with the assessor's office, we'd ask to move it to that date.
Okay, to the assessor?
Yes, we're in agreement with that. If we could just add a 30-day proviso, just in case there's more information needed on this one. We still need to review what was provided to determine if anything else is needed.
Okay. And Mr. Brawl, is that acceptable to you, the proviso?
That's fine.
Okay.
Yeah, that's okay.
Okay, go ahead, Jim.
I'd like to make a motion that we continue this case to April 28th with a 30-day data proviso from today.
I second the motion.
There are no objections. Motion carries. Okay. Okay, and then we have items 40 and 41, application numbers 23-10963 and 23-10964, 1 Baxter Way LP.
We've provided most of the information to the assessor's office. They've requested our valuation. It's an office building. There's a portion of the land that was entitled prior to the lien date 1/1/23. Since that time, the development has stalled. They haven't been able to move forward with the development. So there's a lot of kind of issues at play. Admittedly, it's as a 1/1/23 is the date of value, but we're just going to send our valuation over to the assessor's office. We just need more time to get them that.
Okay, and then do you have a date in mind for your continuation? Well, we'll go to the assessor.
Yeah, the assessor agrees with that. Yeah, and if we could add the 30-day proviso for the missing information. And it makes sense to keep this with the other one, which is the 4/28 date, if that works.
Yeah, is that acceptable to you, Mr. Brawl?
That's okay with us.
Okay.
That would work good.
Okay, got it, Jim?
I move that we continue this case to April 28th with the data proviso with data due to the assessor 30 days from today's date.
I second the motion.
There are no objections, so the motion carries. Okay. Thank you, Mr. Brawl.
Mr. Brawl also has items 46 through 52 on the agenda on page 6, if we'd like to address that while he's standing there.
Sure. Okay. Items 46 through 52, application numbers 23-11786 and 23-11792, UG2 MR LLC.
We actually are recommending a withdrawal to the taxpayer. We just need some more time to go through everything with them and get their approval prior to withdrawing. We had let the assessor's office know as well that we don't think it'll come back before the board, but we just need further time to get approval.
Okay. And to the assessor?
The assessor's fine with the continuance. Did you mention a date? I didn't hear a date.
Do you have a
Maybe the
preference?
same
Same date?
428, just keep them all together.
Right.
Yeah.
Yeah.
Yeah, that's agreeable with the assessor. Due to the circumstance of a possible withdrawal, I don't think we need a proviso for this one yet.
Okay.
Yeah.
Sounds good.
Just to clarify, so if Mr. Ball can't get his client's consent to withdraw, then on April 28th, we'd discuss outstanding data? Is that kind of where the assessor's approaching that from?
Yeah, that would be our assumption there.
Okay.
Yeah.
Thank you for clarifying.
And if for some reason we can't get approval to withdraw, we can, obviously, with the assessor's data proviso, we can move forward with that.
Okay.
I don't foresee that happening, but
Yeah,
in
okay.
case.
Okay. So we're looking for a motion to continue to April 28th, 2025.
I make a motion that we continue to April 28th, 2025.
I second the motion.
There are no objections. Motion carries. Okay, thank you, Mr. Brawl.
Thank you. Have a great day.
You too. Okay, so we are at
43.
43. Okay. Item 43, application number 23-11257, Offshore Crane and Service Company.
This is a request to approve a stipulation agreement where the reduction is exceeding $5 million. Any reduction exceeding $5 million is placed on your board's agenda for discussion and giving you the ability to ask the assessor any questions. This was emailed to your board on Friday for review. So if you have any questions, now is the time, or you can make a motion to approve the large reduction stipulation agreement. Thank you.
Okay, I received this information last week via email. Did my fellow board members also receive it?
I did as
Review
well.
it?
Yes.
Okay. Maybe the assessor could just give us a quick explanation, since it is such a big reduction.
Yes, 1 second. Okay. Sorry, I had to pull it up here.
No problem.
So we had to remove some items that were essentially valued on the roll initially. So we had to remove some vehicles that were registered with the DMV. When it's registered with the DMV, we don't also do property taxes. Let's see. That's essentially the bulk of it there. If you have any specific questions, I can.
So these vehicles were mistakenly assessed because the assessor didn't realize they were already registered?
So we assessed them on the property tax rolls, issued the assessment, and that sort of thing. They appealed, sent us the information showing they were registered with the DMV, which means we improperly assessed them in that case. Yeah.
Okay, well then I'm looking for a motion to request the approval of the reduction stipulation agreement.
I move that we approve the stipulation agreement.
I second the motion.
There are no objections, the motion carries. Okay. Takes us to, looks like, items 53 through 55. Application numbers 23-11842 and 23-11843, and also 24-10032 for Property Company.
Chair Lunetto, we have John Origer here in person.
Good morning, members of the board.
Good morning, sir. What would you like to do today?
We did provide information to the assessor, but it was a little bit on the later side. So we were going to ask for a continuance to give the assessor time to review the data, and hopefully we can resolve the matter without coming back to the board.
Okay.
I would like to ask, though, I do have a conflict on April 28th. Could I move it? Could we ask for, I think the next date I heard was May 19th?
May 19th is the next available one, correct? And to the assessor?
The assessor is agreeable with that. And I believe we've received all the information on this, so we just need to finish our review.
Okay.
I'm sorry, I missed it. Is this 53, 54, and 55? Or is this just 53 and 54?
Correct, all three.
All three? I move that we continued to May 19th for all three of these cases.
I second the motion.
There are no objections. The motion carries. Thank you, Mr. Horger. Appreciate
Thank you.
it. Okay. And item 56, stipulation agreements. These were sent to us last week. I received a copy and reviewed them. Did my fellow board members also have a chance to review them?
I did.
Yes.
Okay. Okay, I'd like to move that we approve the stipulation agreements.
I move that we approve the stipulation agreements.
I second the motion.
No objections, the motion carries. Okay. So, back to
Item 9 is the only item remaining active on your agenda.
Right.
So if you'd like to take a brief 5-minute recess, maybe a little rounded up to 10:30, we'll get everything set up.
Perfect.
And work with the applicant, show them how to use their microphone and so forth, and collect their findings of fact payment, and then get started at 10:30. Does that work for the board?
That's perfect, Brennan. Let's do that.
All right. Mr. Aviles, Mr. Costales, if you want to come forward. We're going to have you guys sit up here so you're comfortable, so come on with me. Take a seat right here, make yourself comfortable. right, we're back on the record.
Okay, welcome back. Again, this is item 9 on the agenda, and I think we'll start with the assessor. Could we get an overview of the case from the assessor?
Yes, thank you. Joe Phillips with the Assessor's Office. Today, we're dealing with a change in ownership related appeal. Today, the board will be determining for their subject property, did a change in ownership occur on April 8th, 2005? And do any exclusions apply that would consider this not to be a change in ownership? This is a single-family residence. The applicant today, Jose G. Reveles, the parcel number 204-0161-070. So part of the question we have this morning, the assessor wasn't too sure, and perhaps the board needs to make a determination, or perhaps it's already answered, but who has the burden of proof in this situation? I believe the burden that we have to prove is the deed presumption. The deed presumption is basically any name that appears on a deed is assumed to have ownership of the property. And so in this scenario, we do think it would be the applicant that has the burden. Also, the other issue is we don't have a homeowner's exemption on the property, so we don't have verification that this is the applicant's primary residence, because I know for owner-occupied single-family residences, the burden shifts to the assessor. So we're not too sure where the burden rests in this case. Is it the one who has to overcome the deed presumption, or is it the assessor, since it's potentially a owner-occupied single-family residence?
If the assessor could remind council the property tax rule that deals with deed presumptions?
Yes, deed presumptions you'll find with property tax rule 462.200.
Thank you.
You're welcome.
Before we hear from the applicant on that, I'd like to place Mr. Reveles under oath. Mr. Reveles, please stand. Raise your arm. You solemnly affirm that the testimony you're about to give and the matters now pending before this board will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may now be seated. Just to note for the record, the applicant has requested and paid for written findings of fact. And real quick, I don't know if this makes a difference in County Council's analysis. While the appeal was filed in the 2021 year, we're actually discussing a change in ownership that occurred on April 8th, 2005. And so, Mr. Reveles, did you live in the property in 2005 when the title changed?
Yes, sir.
Okay, thank you. And you continue to live there now as your primary residence, correct?
Yes, if God allows me, yes.
Okay. So we'll wait for County Council to look into that.
Okay.
in this hearing, because the applicant is seeking to overcome the deed presumption, the applicant has the burden of proof, and it must be established by clear and convincing evidence.
Okay, thank you.
So the applicant can go first.
Does the applicant accept the burden of proof?
Yes, we do. Mr.
Okay.
Chairman.
And you may,
And applicant's
Oh.
Exhibit 1 has been submitted and distributed to your board. It's a series of deed recordations, and that'll be identified as applicant Exhibit 1. Thank you. Please proceed when you're ready.
Thank you, Mr. Chairman and members of the board. We come today after Mr. Reveles has attempted to appeal the assessment made by the property tax assessor as to the change of ownership beginning, and I'm going, when I say beginning, I'll be moving backwards, but beginning in 2005. However, it's Mr. Reveles' contention that equitable ownership of the property has not changed since he acquired ownership in 1989. That, hence the 3 rescission deeds. That would take us back to 1989. The understanding between the members of the family who do appear on the recorded title throughout that period is that equitable ownership has always been in Mr. Reveles. They have at different times assisted him with the use of that property, actually beginning with the acquisition of that property. I believe you were 18 years old at that time, very, very young, and it was difficult for him to finance the property. However, with the assistance of his family, he was able to acquire title, and he maintained title and in all other respects, paid the property tax, paid the mortgage payments, maintenance, and all the other expenses related to the property since then. And the other changes in title were also mere conveniences for him to have been able to utilize the property as a vehicle to obtain financing for other interests that Mr. Reveles has in the community. And across that time period, after the appeal was brought forward, initially Mr. Reveles provided certain evidence of those bank statements, loan documents, documents showing proof of residence, tax returns, canceled checks, and various other documents that were in his possession. Unfortunately, whatever was not provided, Mr. Reveles concedes there probably were items that would fill certain periods within that 89, 99, 2009, 30-some year period. However, some of those documents have been misplaced or lost, and others were damaged in flooding that occurred at the house. So basically, Mr. Reveles has provided, at the time I became involved, he had provided everything that he was in possession of. At that point, I reviewed the assessor's position, and it appeared that written declarations by those family members may assist the assessor in the establishment of clear and convincing evidence of what I've described. So we were able to draft those declarations and have those executed by the relevant family members. Those were also submitted to the assessor. It's my understanding, Mr. Reveles tells me this morning that a previous, it sounds like a hearing may have begun and then continued. Must appear on that list. There were those members who executed those written declarations appeared here. Is that what happened?
Correct, they came in here.
Appeared and testified before this board. Subsequent to that, the assessor still had concerns and left the only option that I could see moving forward was to have those family members execute the deeds of rescission, which you have before you. And so those were executed late last year and recorded, and we basically leave the matter there.
Excuse me, Chair, may I ask some questions?
please.
Do you have copies of the declarations that you referenced for the board review?
I do not have those with me today, but I can certainly submit those if the board is going to deliberate on the matter. I believe the assessor has, if I'm not mistaken, has those in their files, as well as the other records, the remaining records of property ownership, residence, and mortgage payments and those things. I don't have those in my possessions. I do have the declarations. I'm not sure I have the executed versions.
So I have provided all documents, my income tax, my resident, everything that is possible. Joe has reviewed. It's a long process. As you know, my English is not so well, and being here makes me very nervous, but I have presented. And as I said, this house was really the vehicle for me to be who I am now. I got loans, and you know, every family, I mean, almost every businessman needs loans. So I started a small business, and this was really the how I succeeded into my business because of this particular house that I bought when I was 19 years old. So my brothers can testify and under oath what happened. But since I didn't have a father, they were like my mentors. And this is what I do now. I mentor kids that can follow my path. In fact, I came in a national magazine as a in the front coverage, how we can get kids out of trouble and how can they achieve some goals. And let me tell you, this house was probably the best thing I ever happened to me, that I bought my house when I was 18, and I was able to finance and get money, and that's how I own now almost half of the street of Commercial Avenue, and my shop is one of the largest in the area. So, I mean, only that some of these documents that I have payments that I made, mortgage payments, my insurance. I showed them my insurance as my primary residence. I mean, the terminology is not so well for me, but as a insurance, how do you call that? Insurance.
The primary
insurance, I was always there. Every repair that I did to the house was financed by me. My brothers never got any money from there. It was only me that I got all the money, and they can prove with their houses as well.
Well, and counsel, the reason that I didn't bring those forward today was just my interpretation that the rescission deeds basically say the same thing. The rescission deeds would indicate to me that the transfers never even happened. They remained, the title remained in Jose G. Reveles throughout that entire time period. And that would bring clear and convincing evidence in the form of the face of the deed, the recorded chain of title, and wouldn't require the further evidence. But if that would be necessary, they do exist. We could certainly have them for the board.
May I ask another question, Chair?
Yes, of course.
You referenced that there was a previous hearing where family members testified. Do you know the date of that hearing?
They didn't testify, but they came here. My two brothers came in here. We didn't have the opportunity, but they walk in here in case because I don't know how these protocols work. So I brought them because I thought it was time for them to address everything. They're willing to come and address the issue.
And that's my mistake, Madam Counsel. I just heard of that this morning. I wasn't aware. It was confusing to me. If the hearing was continued, that would have been why they never testified to this point.
Okay. Okay. This is obviously an important decision to decide was there a change of ownership. So what you've provided to me are two deeds, it looks like, what you provided to the board.
There are three there, Mr. Chairman. The older of the two do not appear the same. They're not the complete deeds. They're just the face showing the recording of two, both from the year 1991. but those are in fact two different deeds.
Okay.
Instrument number 352 and the other one, instrument number 591. And the final instrument ending in 353.
Okay. Okay. Does the assessor have any questions for the applicant regarding their presentation?
Yes, we do.
Okay. Whenever you're ready.
So, Mr. Constalis, as mentioned previously, we have the deed presumption. The names that appear on the deed are assumed to have ownership, and it has to be clear and convincing evidence to support that that's not the case, that the names on the deeds don't have any beneficial ownership. So my question is, for the, April 8th, 2005 transfer, can you tell us the exclusion that should be applied to this transfer to where it should be considered not a change in ownership?
Yes, Mr. Phillips, we're not aware of any standard exclusions. This would be amongst siblings, so there is not an exclusion for siblings, but it would follow the same, our same reasoning that there was no equitable ownership that was considered to be acquired by, didn't already exist prior to that. So I think what you're asking is when the brother and his wife, as well as Jaime T. Reveles and his wife, executed the deed back to Mr. Jose G. Reveles, there wouldn't be an exclusion, a traditional exclusion, other than they were just effectively cleaning the title up, returning it back to their brother, who maintained the equitable ownership in the property throughout since 1989. And that being shown by the initial evidence that was provided, everything that Mr. Jose G. Reveles was in possession of with respect to the property mortgage payments, tax payments, and maintenance and the like.
I was living in that house, carrying the payments. My kids were attending the school. Neighbors knows about us, almost all neighbors. We've been living there since then, since 1988. So they all know us there. And so I live there. I show you my income taxes during that time that I was residing in since the beginning. So only that I don't have some of these mortgage payments because my house got flooded. I can prove that there was a loss in my house, and I lost most of those papers got mold, and I had to get rid of them.
Mr. Gonzalez, I don't see a legal analysis in here that shows, the sources from the BOE or any other legal sources that kind of explain how this can be excluded from a change in ownership in your presentation. Do you have any sort of legal analysis that shows the recording of these rescission deeds means that this should not be considered a change in ownership?
Just the property tax annotation 220.0149 that it shows that if clear and convincing evidence can be provided as to the beneficial ownership of that property, that this would be the ultimate, and coupled with anything else that's available, this would be the ultimate evidence that could be provided, would be these other names, the individuals whose names are relevant to this matter, relinquishing any interest that they have and had in the property back till 1989.
My brothers can testify, I mean, they claim their house, they live in their house, different address, they can prove that that's why they came here. I provide even with their driver license that they live in their own houses, and pretty much they live in their house, I live in my house, only that they help me to finance over the course of my life and businesses. You know, sometimes to expand a business, you need loans, and that's how this property is being utilized as a vehicle for me to do what I'm doing now, a business owner.
I'm sorry, can you repeat the property tax? You said property tax annotation?
Yes, and as much as I hate to use, it's coming. Thank you for the, I may add that the assessor did cooperate with us quite well throughout this process, and I'm taking it right from the communications we've had. Property tax annotation 220.0149.
Okay.
Related to overcoming the presumption of equitable title based on the names appearing on the face of the property deeds.
So that annotation, as we discussed, specifically does reference rescission deeds and how they're to be treated legally. In that it says that rescission deeds are only prospective. Essentially, the assessor and the board today can only enforce rescission deeds prospectively. How are you able to overcome that legal requirement?
We would, that being the case, we would urge the board, or if the assessor is in the power to, has the power to reconsider in the form of a settlement, that it could be the assessment as of 1989 could be applied prospectively from here going forward without concern in what's happened since then, from then up until today.
Right. That would not be a subject of this appeal. This is only we can only deal with 2021. These rescission deeds were recorded October 1st, 2024, meaning prospectively would mean they can only be applied January 1st, 2025 moving forward. So the subject of today's appeal, I'm trying to ascertain kind of your legal argument and your legal sources that would allow us to change the 2021 value or consider the 2005 transfer to not be a change in ownership.
Well,
retroactively, essentially.
As I say, yeah, if it being applied prospectively, we would understand, or we would be in a position to accept an assessor's application prospectively from here going forward, that value as of at least back to the date of the 2005 transfer would be applied going forward prospectively from October of last year moving forward in future tax bills based on that assessment.
I would explain to you and the board today that that's not possible based on what's been appealed. These would potentially go into effect January 1st, 2025, based on the law you just quoted. That is beyond the scope of this appeal. It's beyond the scope of what my department can influence. We can only influence what's been under appeal. The rest of the assessor's office still needs to review these deeds and determine if they have an effect on January 1st, 2025. again, that is the current open roll processing and not part of this appeal.
I understand.
Okay. The next question I would have is, I think you touched on it, but we have a series of deeds that were recorded from essentially 1989 to 2005. It would be 1, 2, 3, 4 deeds total. Various names from the family are recorded at different times. I would just like an explanation as to why these deeds were recorded in the first place.
And if you'd like to, I know that had wanted to speak, feel free, Mr. Reveles.
So I bought the house. So I bought the house very young age, and my brothers protect me in case, when you're young, you don't. So they put the house on their name, Juan, Delia, Manuel, and Marta. Even though I own the house, they knew it. In 2008, my brother Juan decides to go to Mexico. He deeds the house to me. In 2019, 2002, 2001, I acquired a business and I needed a loan. So I refinanced that house to get money so I can operate. And all that money went towards me. My brother never got any money. So I started operating. 2005, I did another expansion in my shop. I bought another shop, and I can prove that. So that's when I also got another loan. In fact, it was a line of credit under my name. My brothers didn't get any money at that time because it was a line of credit, and then that's the history of those deeds. I'm sorry that might not be so clear because my English is not that best but I mean, that's my description. I've seen a lot of people get loans in ways where they can construct a loan. That's how, like I said, the money was utilized completely on commercial auto body, and that's how I expanded. That's how I was able to do what I did. By the way, it has worked for me. But I've been living in the house since then. My kids went to school. My taxes are being there. I claimed the homeowners insurance since
The
exemption. I got all that as well. So I tried many times to do an appeals, but not having the time or sometimes not the right direction, I would just do the appeal and not complete it because of, I was self-employed, working hard, and I couldn't. Now I got more time. That's why I've been going further than this. But I had done, previously I did an appeal for these. Unfortunately, I didn't complete them.
And to answer your question, Mr. Phillips, yes, I think that was consistent. The answer of the portion that answered your question consistent with my summary earlier, that it was basically in order for him to initially acquire the property, and then in the second two instances in order to obtain financing for his use to grow his business.
Thank you. That would conclude the assessor's questioning.
Okay. Does the board have any questions for the applicant?
I have several.
Please, Jim.
And this is for either Mr. Gonzalez or Mr. Constales. I thought I heard Mr. Gonzalez say that there was a homeowner's exemption on this property. Is that true?
Member Wall, is that Mr. Reveles you're asking about, right?
Oh.
I believe Mr. Reveles might have answered the question of the clerk earlier about homeowners exemptions in place.
Well, I thought he just.
I did
well.
provide with the homeowners insurance as me, Jose Reveles, the beneficiary as a homeowner.
Oh, homeowners insurance.
Yes,
Got
homeowners
it.
insurance.
And then my other question has to do with the application that we have here. This applicant's opinion of value is $114,000. Was that the purchase price you paid back in 1989? What is this number?
So I provide the first purchase, and I think it was 80,000, maybe I run it up, but yes, it was on the 80s. I don't know if it was low 80s or high 70s.
Well, the board member's asking about 114,000. That's what we believe was set. That would, to me, indicate, Mr. Wall, that would have been in 1991 as of the first transfer that included
Okay.
names other than Mr. Jose G. Reveles.
Thank you. I have no further questions.
Thank you, Mr. Wall.
I have a couple of questions.
Okay, please go ahead.
Yes, just so I can track with you. Did you turn 18 in when? What year?
No, I was born in 1963, so this is not 20. I was
So when you first took possession of the house, you said you were 18?
No,
is that correct?
I started saving money at 18, so we bought the house in 84. So I was 21.
So
21.
when you were 21, you bought the house in 1984?
That's when I think it's 83, 84. I remember that.
Okay, I'm just asking approximately if you don't have it right in front of you. Okay, now, between 1984 and 2005, who was living in the house?
I did.
And were any of your siblings living there also?
As you know, how we Mexicans live, Jaime never lived. Juan did live there because he was a farm worker. He was a seasonal guide. He would go back and forth.
Well, you could just say yes or no if they were living
well,
there.
yes.
Did they contribute to the paying of the mortgage and the taxes?
No, ma'am, no.
And who paid the mortgage and the taxes between 1984 and 2005?
I always paid everything.
Okay.
If they leave, they give me a little rent or something, but I always paid it, which was hard for them because they were seasonal farm workers.
Okay. And you said that your income tax returns were submitted. On your income tax returns, did you deduct the mortgage interest?
Yes, I did.
And for what years did you do that?
Well, I started my shop as my business as a hobby. So I in 2002, I believe that's when I made a little bit of money to really, because it was a hobby. I was single. That's when I filed kind of my income tax again because I was working like in the shadow, if I can say, I'm sorry, but it was it's an auto shop where people would bring their cars, and at first I used to fix my own, and then neighbors would come, and then that's when I said, this is what I should do.
Did you start filing the income tax returns in 2002 is when you first started filing?
Correct.
Okay. All right. Okay, I don't have any further questions. Thank you.
Thank you.
Okay. I think we can hear the assessor's presentation.
I'm sorry, it was
It's
something.
back to the assessor.
Are you going to ask about Rule 313C? Is that what are we going to
Yes, I was going to mention, so burden of production. In order to properly follow the board procedures, the board is required to make a determination about burden of production. The assessor's office is asking for that for every case moving forward, just to make sure we're following procedure correctly. So we would ask the board make a determination on that prior to the assessor giving their presentation.
Okay, understood.
Mr. Chair?
Yes.
I'd like to just read the rule for the board.
Okay.
Yep. It's Rule 313C. In applications where the applicant has the burden of proof, the board shall require the applicant or applicant's agent to present his or her evidence first, and then the board should determine whether the applicant has presented proper evidence supporting his or her position. This is sometimes referred to as the burden of production. In the event the applicant has met the burden of production, the board shall then require the assessor to present his or her evidence. That's the portion I'll read.
Okay.
And say if the board wants to deliberate if they've met the burden of production in closed session, you're free to do so, or you can do so here on the dais openly.
I would actually like to deliberate in closed session briefly with my board members and council.
We're back on the record.
Okay, there we go. Okay, thank you for waiting patiently, we appreciate it. County Council is actually going to make a statement that will help explain what we were discussing and what we've decided.
The board deliberated on the pending motion brought by the assessor's office on whether or not the applicant had met the burden of production. And the board was also mindful of a portion of guidance contained on page 103 of the assessor's assessment appeals manual dated May 2003, reprinted January 2015. And that portion of the manual, and I will just read it for everyone's benefit. The section I'm reading is entitled, Board Must Have Sufficient Information to Make a Decision. In order for the appeals board members to properly adjudicate any matter before them, they must be presented with sufficient information to render a decision. Board members should be diligent in asking for clarification in areas of uncertainty. A decision should not be based on inconclusive evidence. If, in the opinion of the board, not enough information was provided during the course of the hearing to make a decision, the board may continue the hearing so that information they believe is pertinent may be assembled and brought before them. And the issue the board has is that the applicant's representative and the applicant referenced all matter of underlying support that would tend to overcome the deed presumption, but none of that was marked into evidence and presented here today. And the board understands from where the assessor is making the motion on the burden of production, but because this body of potential evidence was referenced but not actually shown to the board is continuing this hearing until March 17 is the date, subject to both parties saying they can make it that day. In order for the applicant to bring evidence that meets the test of Rule 462.200, if it exists, sworn declarations accompanied by such written evidence as may reasonably available, such as written agreements, canceled checks, insurance policies, and tax returns. Things that show that Jose G. Reveles, in fact, is the exclusive beneficial owner as well of this property. So if you've borne the burden financially of paying the mortgage, of paying insurance, of paying property taxes, of being listed as the homeowner of record on insurance policies, along with declarations from your siblings that would establish all this, that is what the board is looking for the continued hearing date. Once that information is presented, the board will rule on the assessor's pending motion and decide which way it, if it's going to ask the assessor to put on its case in chief.
Thank you. Well, to the assessor, is that clear? Do you have any questions?
That was clear to the assessor, and as the applicant was presenting, we were thinking that might be beneficial for the applicant to have another chance to present that kind of evidence to prove his point that essentially to overcome that deed presumption as outlined in the law. So we are in agreement with the board's decision.
Okay,
there.
great. And to the applicant, I just want to reiterate through your testimony, what we heard was there were written declarations that Mr. Reveles paid property taxes, all expenses associated with the property. made loan payments, paid homeowners insurance, and filed income tax returns where the mortgage interest was claimed on this property. But we weren't provided with those actual documents. That's what we would need in order to properly consider them. Does the applicant have any questions?
No, Mr. Chairman.
I present all my income taxes to Joe and house payments, insurance.
No,
Right.
but they need it here.
Oh, okay.
Yeah, exactly, and we understood that. No, it's okay, we understood that.
Okay.
That's why we know they exist, we believe you that they exist, but we have to actually
Right.
see them, and they need to be entered into evidence. So with that being the case, we would suggest continuing this hearing to March 17th, 2025, if that will work for both the assessor and the applicant. To the assessor?
Maybe, Mr. Costaus, will you be able to gather the documents the board is requesting to present those in 6 copies at the next hearing?
I'm confident that we can, yes, Mr. Clerk.
Okay, so March 17th would work with the assessor. I just want to clarify for the applicant, because it did sound like he's a little confused. Yes, you did provide that to the assessor, but the documentation you provided to the assessor, the board would not have access to, right? So you would have to present those to the board separately, okay? So that's what that is.
And if I may, Mr. Chair, if the attorney has any question, he can talk to the clerk about the number of copies and all that.
I'll just, Brendan, Deborah made a good point. When is our next board meeting, Board 2?
Board 2, March 17th is the next time
Perfect,
the three of you
okay.
will be here. Yes, so it
Well,
is
then
the
that
three
works
of
out.
you. Yeah, we don't want to switch this case to a different board.
no,
So
no.
assuming no, let me actually double check that because we're actually doing a roundabout assignment now. So just a second. Let me make sure. March 17th.
I have that as a.
Yeah, we have Lunetto, Walt, and Cohen present on March 17th. So
Okay.
the three of
Does
you will
that
be
date
here.
then work for the applicant?
Yes, Mr. Chairman.
Okay, okay. Let's see, do we need to make a motion, Brennan?
Just to be clear, it sounds like the board decided that in closed session, but now that the parties have confirmed, so just continuing to March 17th, 2025, with the request that the applicant produce additional documents at that hearing.
Correct. Do I have a motion?
I move that we continue this hearing to March 17th and the applicant provide the required documentation for us to move forward.
I second that motion.
Okay, no objections, motion carries. Thank you, Mr. Reveles.
Thank you.
We will see you, and Mr. Costales, we will see you on March 17th.
Thank you. Thank you all.
Okay, thank you to the assessor. And
There's no other items of business. If you'd like to adjourn, the time is
Okay.
10:47 a.m.
we
I
are
mean,
officially,
11:47.
we are
sorry.
officially adjourned. Okay. All right.